of what one human being can do to not one, but 3 human beings. It is incomprehensible. You cajoled, lured, and deceived Shatisha Shealy, Angela Deskins, and Sherelda Terry to your apartment for your depraved purposes. You went on to abuse the corpses of these 3 victims. You stripped them from the waist down. You folded them in half, binding them so that their feet were up by their ears. You wrapped them in multiple layers of trash bags, and you discarded them. Upon consideration of the relevant evidence, the testimony exhibits admitted in mitigation, it is a judgment of this court that the aggravated circumstances of course of conduct, felony murder, kidnapping, felony murder, rape, of which the defendant was convicted, outweigh the mitigating factors by proof beyond a reasonable doubt. Accordingly, the sentence of death is imposed upon the defendant, Michael Madison, on counts 1, 4, and 7.
Mr. Gillard, having been convicted of the murder in the first degree of April Holland by unanimous verdict of the jury, duly returned during the term of Superior Court of Wake County, North Carolina, and the jury having unanimously recommended the punishment of death, it is therefore ordered and adjudged that the same Siaga Edward Gillard be and is hereby sentenced to death. And the Sheriff of Wake County, North Carolina, in whose custody said defendant is now, shall forthwith deliver said prisoner, Siaga Edward Gillard, to the warden of the State Penitentiary of Raleigh, North Carolina, and the said warden shall cause said prisoner, Siaga Edward Gillard, to be put to death as by the law provided. Siaga Edward Gillard, having been convicted of murder in the first degree of Dwayne Garvey by unanimous verdict of the jury, duly returned in the term of Superior Court of Wake County, North Carolina, and the jury having unanimously recommended the punishment of death. It is therefore ordered and adjudged that the same Siaga Edward Gillard be and is hereby sentenced to death. And the Sheriff of Wake County, North Carolina, in whose custody the defendant now is, shall forthwith deliver said prisoner, Siaga Edward Gillard, to the warden of the State Penitentiary at Raleigh, North Carolina, and the same warden shall cause said prisoner, Siaga Edward Gillard, to be put to death as by the law provided. This, the 4th day of March, 2019. May God have mercy on your soul.
Therefore, this panel finds that the death penalty is appropriate, should be, and is hereby given for each of the 4 murders by the defendant. It is therefore the sentence of this court as follows. At case CR 13-2768, count 1, murder in the first degree, a class 1 felony, death. Count 2, use of a deadly weapon, firearm to commit a felony, a class 1C felony, 45 to 50 years to run consecutive to all murder convictions at counts 1, 4, 7, and 10. Count 3, possession of a deadly weapon by a prohibited person, class 1D felony, 45 to 50 years to run consecutive to all murder convictions at counts 1, 4, 7, and 10, and count 2.
After having conducted the required weighing process and analysis, this court finds that the state of Ohio has proven beyond a reasonable doubt that the aggravating circumstances associated with count 1 outweigh the mitigating factors. The court further separately finds that the state of Ohio has proven beyond a reasonable doubt that the aggravating circumstances associated with count 7 outweigh the mitigating factors. The court therefore concurs with the jury's sentencing verdicts regarding counts 1 and 7. The court therefore finds that a sentence of death by legal injection shall be imposed upon Mr. Great for the aggravated murder of Elizabeth Griffith as stated in count 1 of the indictment, and a sentence of death by lethal injection shall be imposed on Mr. Great for the aggravated murder of Stacy J. Hicks, a.k.a. Stacy J. Stanley, as stated in count 7 of the indictment. Court further orders that each of the death penalties be carried out by appropriate authorities on September 13, 2018, which would be the 2-year anniversary of Mr. Great's discovery.
The Bible says we have to love our family, but I don't have to be around my sister Sue anymore. You have put a scar on my heart and my family's heart. You have lied to family and friends over and over. Can I forgive you? I don't know. Can God forgive you for what you've done? I don't know. As you do your time given, think about what you've done and be ready to suffer the consequences. And that's all I have to say.
Thank you, Mr. Salem.
It's a terrible situation, obviously, and it's really created some emotional trauma to the family as a result of what's happened here. We recognize that the defendant does have some issues herself, and she was placed in a position of having to render hospice, if you will, to her mother. And she was challenged by that, and obviously she took the wrong path in administering the medication to her mother.
I only did what I was instructed to do by a nurse. And God knows my heart, and God knows the truth. That's it.
When I sentence you, Ms. Kubitschek, I balance the principles of punishment, rehabilitation, protection of society, as well as deterrence. I consider the positive and the negative things you bring before the court. You were entrusted with the care of your ailing mother, and I can certainly understand the frustration that you were in and maybe some realization of your mother's condition. However, what you did was inexcusable. According to the investigation, your mother, Ms. Allen, was supposed to get 10 milligrams of morphine every 15 minutes to an hour as needed, and you put together 10 milliliters every 15 minutes, which is, according to the assessment here, 80 times more than what she was prescribed. You were, for a period of time, responsible for her care. A vulnerable person who could not take care of herself needed somebody to care for her. And you disregarded that responsibility and took matters into your own hands.